One thing I would like to bring up, although we've talked about all of the legal implications, legal decisions have practical impacts. And just because you can do something doesn't mean you necessarily should. The question I have, and this has been a topic of discussion concerning a concealed carry state, whereas people can carry their guns to protect themselves from evildoers. Anyone who has carried weapons and dealt with weapons professionally get a little nervous about a lot of excitable amateurs carrying guns in a situation that maybe they're not prepared for, or seeing people carrying battlefield weapons around to rallies, and you have questions about what value that would be. How do you handle some of these practical implications and results of the legal decisions? Things like people possibly being a danger to themselves and others, even though it's their right to do that.
Well, there is no right to go into public and handle firearms in a reckless way. It's a crime to brandish or exhibit a firearm in anger, or to point a firearm at another person, creating a reasonable apprehension of bodily harm. So there's a whole array of criminal laws on the books, and if you go into any of the particularly misdemeanor or even felony criminal courts around the country day in and day out, you'll see people charged with offenses like that, of brandishing or of pointing or otherwise creating apprehension of misuse. The majority of states now have what we call shall issue permitting systems, where a person can get a permit or license to carry a concealed weapon, but there are qualifications, including training, and that's pretty universal. There's a smaller number of states now that have discretionary issuance where it's up to the police or sheriff whether you get a license, and those can be very unfair because they tend to give licenses to their friends and to deny them to poor people or people they don't know or care about. And I think the Heller and McDonald set of decisions, if McDonald is resolved favorably, will bring more procedural due process to permitting systems, particularly where there's discretion. It will not do to just say that I don't think you have a need for this firearm and therefore I'm going to turn you down, but I'm going to get a license to somebody else. As to open carry, keep the following in mind, that when this country was founded, when the Constitution was adopted, there were no laws on the books of any kind about carrying firearms, either openly or concealed. The first concealed weapon statutes were passed by Kentucky and Louisiana in about 1813, and it had to do more with the dueling code than with any safety issue. And people got along quite well back then without any laws on the books. The only laws on the books required militiamen to have arms, required people in certain areas where there was dangers of Indian attacks to carry arms to church. And things seem to have gone quite well in those days. The idea of a permit to carry in any form, openly or concealed, we can talk about the Sullivan Law in New York, where they were prejudiced against immigrants coming into the country. And I think the bottom line is, without extending this overly, is that there are laws, plenty of laws on the books that prohibit misuse or the kind of promiscuous use of firearms that are endanger other people, and that probably the concealed weapon type system is best for all, as opposed to the open carry that was more traditional, because an old lady doesn't have to see a gun and get scared.
If I could just add one small point to what Steve said. The modern trend towards shall issue, in other words, very liberalized granting of licenses for concealed carry, began in Florida in 1987. And when that was being considered, and shortly after it was adopted, police chiefs and commentators all over the country predicted it was going to be Dodge City, there was going to be blood in the street, crime was going to go up. It never happened. We now have, I don't know, what is it, Steve, something like 44 states that have these laws. The rate of misuse of firearms by concealed carry holders is minuscule. It's probably lower than the rate of misuse of firearms by police officers. It just doesn't happen that giving people their liberty results in anarchy.
Yes, this gentleman here.
Thank you. Hello, I'm Dane Van Brykenroockert. I'm president of the U.S. Bill of Rights Foundation. My question is to both of you. I'd be interested in hearing it. I think I know the answer, but I wanted you all to kind of discuss it. In the decision that is going to be made in the case coming up, is that are the two terms synonymous with each other? You have to have what is called in the decision-making process a fundamental right. Is a fundamental right always necessarily held when a case is being heard under strict scrutiny? Do the two go together? So that if the court, for instance, this time, suppose they wanted to come back and say, I tell you what, let's give them what they want. They want incorporation, let's give it to them. But let's don't give it to them where they can use strict scrutiny in future cases. Some sort of a modified intermediate level of scrutiny can be used. And so what the core of the question is does one depend on the other? Can you not do that? In other words, do they say, well, if you're not going to allow us to use strict scrutiny, then it's not fundamental. So that's kind of where my question is on that. And very quickly, then what is the relationship between the Second Amendment and the two clauses in the Constitution under the militia clauses, that Congress can call forward the militia and on, and then the other one is to provide for organizing, arming, training the militia. What is the relationship then, now, today, not then, but now, today, being that it's still in the book, hasn't been taken out?
Okay, so you got two questions in. So the first one is on strict scrutiny and fundamental rights.
Why don't I take that one, and then Nelson talked a lot about the relation between the clauses, and I'll defer to Nelson on that. Chief Justice Roberts is not a friend of non-textual language, and when the original Heller case was being argued, he asked the question to Walter Dellinger, who was arguing for D.C. He said that, look, why don't we ask, does a handgun ban infringe on the right? You know, we judges made up this term, fundamental right, strict scrutiny, rational basis, all that stuff. Those are judicially created doctrines. What's reasonable about a handgun ban? Why does not that infringe the right? And a similar exchange took place in the McDonald argument. Justice Kennedy said, well, it's a fundamental right, and I don't know, we must have decided Heller wrong unless this is a fundamental right to keep and bear arms. And Roberts again made the comment that the issue of incorporation and the issue of whether a handgun ban would be valid if the right was incorporated, he wanted to just get back to the constitutional language of infringement. And I wouldn't be surprised if you might see that in the McDonald opinion when it does come down, that maybe the court will continue what it did in Heller and not say, well, we don't have to resolve strict scrutiny at this point. Although the court in Heller did say twice that when this country was founded, a fundamental right of Englishmen was the right to keep and bear arms. And it's kind of bizarre to say it's not fundamental anymore when it was at the founding. But we would all like to get it, we'd all like the court to say it's a fundamental right and that strict scrutiny applies, because obviously it makes it easier to attack laws on the books that go beyond the strict scrutiny standards. But again, I wouldn't be surprised to see the court be somewhat non-committal and say, as a categorical matter, as it did in Heller 1, that the right to keep and bear arms shall not be infringed. A handgun is an arm, period. The case is over.
Let me just add one thing to what Steve said about strict scrutiny. This is a legal term. It's invented by the courts. It doesn't really mean anything. People pretend that it does, including justices on the Supreme Court, but they've developed these tiers of scrutiny: strict scrutiny, intermediate scrutiny, rational basis with bite, rational basis with 2.5 bites, and all this stuff, and it's all meaningless. Sometimes they don't talk about what level of scrutiny they're applying. Sometimes they say they're applying strict scrutiny, but it's indistinguishable from the complete opposite rational basis. And these are just labels that the opinion writers on the court sometimes put on what they've decided to do for other reasons. So I don't think it's worth getting too worried about the language of strict scrutiny in this case or anywhere else. Now, the second question has to do with the relationship between the reference to the militia in the Second Amendment and the discussion of the militia in Article 1 of the Constitution. As you all know, the Bill of Rights was adopted several years after the original Constitution. That's why they're called the first 10 amendments. The original Constitution gave Congress virtually plenary authority over the militia, to regulate the militia. There are a couple of minor exceptions, things they couldn't do. But they gave them virtually plenary authority. And the original Constitution also said that Congress has the power, and should read this so you all get it, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution, the government of the United States, et cetera. So Congress was given the authority to regulate the militia, and then it was given this other authority to do things necessary and proper for regulating the militia. Now, one possible effect of those clauses would be that Congress might decide, well, we're going to adopt a militia regulation. Remember, at that time, the militia did basically consist of all able-bodied male adults, and Congress was given the responsibility, or the power at least, to regulate the militia, which they did right after in 1792, basically requiring people to own guns and requiring them to show up for military training and so on. So here's something that could happen. Congress might decide one day, well, we're going to regulate the militia by saying that all the guns will be kept in government armories and the citizens won't be able to keep guns in their homes. And we think that's a necessary and proper regulation for carrying into effect or carrying into execution that is Congress's power to regulate the militia. Until the Second Amendment, that would not have been a clearly illegal thing for Congress to do. The Second Amendment says, Congress, you can't do that. And here's how it does that. It says, the right of the people to keep and bear arms shall not be infringed. And so you can see the purpose of doing that. They included this introductory phrase, a well-regulated militia being necessary to the security of a free state. What does that mean? It means that Congress, under its authority to regulate the militia, may not adopt regulations that result in anything other than a well-regulated militia. That's all they can do, is provide for a well-regulated militia. Well, what's the difference between a well-regulated militia and one that's badly regulated? Well, one way would be if it's not regulated enough. That would be one way in which it could be badly regulated. That's the way we usually think of things today. We need more regulation. The only kind of bad regulations are the weak ones, right? That's not the way people would necessarily have thought at the time. One way in which the militia could be badly regulated would be by being overly regulated or inappropriately regulated. And what the Second Amendment does is tell Congress and the nation that disarming American citizens is an inappropriate way to regulate the militia, and you can't do that.
We have one at the back here on the right. One of the examples which Nelson gives, which I like a lot, he says, suppose the dean says that since the professor is sick today, class is canceled. Well, even if the professor is off playing hooky, class is still canceled. As a professor, I kind of like that, and I think that is illustrative of the concept.
My name is Jonathan Zimmer. I'm a law student at the American University Washington College of Law. So we have Heller, which establishes the Second Amendment right, and we're probably going to have McDonald, which incorporates that against the state. As Professor Lund pointed out, a lot of these gun regulations are justified on the basis of statistics, that there's a correlation between allowing citizens to have guns and later violence. Doesn't the cumulative effect of Heller and McDonald, isn't the effect going to be to shift the burden of proof away from people who are supporting more gun rights and putting it on the people who are supporting more gun regulations? In other words, doesn't it become incumbent upon the supporters of gun regulations to justify the regulations with all this evidence?
You know, Dred Scott said that African Americans have no rights that the white man is bound to respect. And up until Heller was decided, gun owners had no rights that any governmental body was bound to respect because of the way the courts were construing the Second Amendment, with the exception of the fact that in the states there are state constitutional rights to keep and bear arms. So in those states, there were rights that had to be respected, but in California, New Jersey, New York State, and places like that that have no state guarantee, it was like gun owners had no rights whatever. So your comment is correct that it does shift the burden. Now, will courts implement that in a legitimate way? That's a problem because even where it's clear under the state constitutional guarantees that go back to the founding in some cases, the right of the citizen to keep and bear arms for defense of self and state, if you had language like that, it was clearly an individual right. And yet you have a state like Ohio where the Supreme Court said that Cleveland could ban assault weapons, and these were nothing but ordinary rifles that were in common usage. So I'm hoping that the Heller common usage standard, the court does talk about, does use the term. Nelson criticized it, but it can be useful, I think. The kinds of commonly used firearms that are kept by law-abiding people for lawful purposes traditionally. There are other courts that preceded Heller in saying that. That can be a useful test because if it's normal, what we today would just refer to as normal rifles, pistols, and shotguns clearly come under that test. So we'll see how much, lower courts rebel at Supreme Court decisions. They try to nullify them in many cases. And so it's going to be a pendulum. It'll be the Heller decision, the McDonald decision will be both a sword and a shield for many decades to come. And by the way, consider yourself privileged to be in law school now when the Second Amendment would even be mentioned, because when I was in law school in the 70s, it would not be mentioned. And if you asked a question about it, like in a con law class, like it would be, is there something wrong with you? So you're lucky.
Okay, this gentleman here. Oh, yes.
Hi. Okay. Assuming a favorable McDonald decision, or favorable for McDonald, I'm wondering how you think that may affect local ordinances. For example, in Maryland, in the city of Baltimore, when they have gone to the state and the state has said, no, that really would not be constitutional to pass that for you, they go back and they pass ordinances, and it appears that their reasoning is, well, the people aren't going to be able to afford to fight it. They've got to go to work and don't have the money. So they pass ordinances that the state has already declared unconstitutional. And I'm wondering how might that play out with a winning, however narrowly, by McDonald?
Well, first of all, there's many states that, I'm not sure Maryland's one of them, but they have state preemption laws. So as a statutory matter, if the state legislature declares something beyond the purview of a locality, the locality can't do it, even aside from the constitutional issue. But I can tell you that if McDonald's resolved in a way that the right's incorporated, citizens will have the opportunity to raise that depending on the type of regulation at the local level. In other words, is it something very onerous? Is it like a high fee merely to possess a firearm equivalent to a poll tax? Or do you have to take some kind of like literacy test equivalent to a literacy test in the old days in the South, for example, to vote? What is the burden? I think the courts are going to uphold some burdens and they're going to invalidate other ones, and it just depends on the specific content of the ordinance.
Okay, this gentleman.
William Worley. I'm wondering why the Supreme Court, since the Bill of Rights guarantees fundamental rights, why would they incorporate the First Amendment and some of the other amendments, but not the Second Amendment?
Well, if they were to do that, it would be because they like the First Amendment and they don't like the Second Amendment.
Right.
That would be the only possible explanation, in my view. And also because they also like obscenity, but they don't like guns.
Incorporate the Fourth Amendment and the Fifth Amendment?
Yes, they like criminals to have lots of rights, or accused criminals. They like pornography. They don't like guns. That would be the only explanation.
So let me ask a question of you both, which I brought up, I take my prerogative, I brought out a little bit in the introduction, is that how do you see our understanding, our evolved understanding of the Second Amendment as affecting the rest of the Constitution? Terms like the people, for example.
That was always a danger with the way some courts went when they basically nullified the Second Amendment, is what does it do to other rights? How does it degrade them? Because if you say the people's not really the people, but it's only such persons that the government chooses to possess arms, and they can only do it when they're on some kind of National Guard duty, I mean, that totally degrades the rest of the Constitution. But, you know, the Bill of Rights is something that's attacked on all sides. Despite this preference for First Amendment rights, we have the incredibly shrinking Fourth Amendment. I mean, we have all the exceptions that have been read into these rights, and even with the First Amendment, it starts out by saying Congress shall make no law, no law, and they make laws as to the rights that are listed thereafter. So, again, it has been, I totally agree with Nelson about they haven't incorporated the Second Amendment yet because they don't really care about that right historically before now. The court has not. And why'd they wait until 2008 to say that the people means the people? And so all of these doctrines that basically treat any one of the Bill of Rights guarantees as somehow not worthy of respect, it degrades other ones, and it leads to these doctrines that there's exceptions to all the rights, and that you know how far can the exceptions go? Well, there is no limit.
Time for, I think, one more question.
Hi, I'm Richard Youngfleish from the Northern Virginia Community College. I'm not a lawyer, and so I know you plowed this ground before, but it seems to me the Second Amendment is all in the context of a common defense, not individual defense. I never know how you got off that argument.
Does it say anything about the common defense?
Yeah, talk about the militia.
Well, it doesn't talk about the militia. It says something very specific. Very specific. It doesn't kind of vaguely talk about the militia. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, in answer to a previous question, I explained the relationship between those two clauses, but let me go back to the point that Alex made. It says, the right of the people to keep and bear arms shall not be infringed. The prefatory language of the Second Amendment doesn't create any exceptions to that. And it doesn't say that the people means the militia. It doesn't say any such thing. It doesn't say that the right of the government to keep up a militia shall not be infringed. It says the right of the people to keep and bear arms shall not be infringed. And that command is not modified in any way by the prefatory language that explains the purpose for which that command was given.
Based upon what you're saying then, what about the argument that people say then doesn't that take us back to Miller? In the Miller case, it was decided on the fact that a sawed-off shotgun was not a type of firearm that would be used by soldiers in the trenches. I mean, they got it wrong, we know, because the other side didn't show up and argue the point. But if we're going to go by what you're saying, then doesn't that naturally invite the argument, oh, well then now now we're talking about the type of guns that are suitable for militia service.
Well, virtually any gun can be suitable for militia service if in certain circumstances. But the Miller decision was, in 1939, was not only confused, but extremely narrow. It just said, it said two things. It said you have to show, the right has to be connected in some way with the preservation or maintenance of a well-regulated militia. And as I explained in my answer to your earlier question, that can be done without compromising the individual nature of the right or disclaiming the proposition that we have a right to keep firearms for protection against violent criminals. The court then said that it couldn't take judicial notice of the proposition that a sawed-off shotgun or short-barreled shotgun would meet that criterion, and remanded to the lower court for that factual issue to be explored, which it never was in the lower courts. Judicial notice, for those of you who aren't lawyers, means something that doesn't have to be proved with evidence. It said we can't assume without evidence that a short-barreled shotgun meets this criterion. Sent it back to the lower courts, nothing ever happened there because the defendants had disappeared, so there was never a trial to gather evidence. So that's all that Miller stands for. And even if it stood for more, the opinion is so confused, has language pointing in so many different directions that it couldn't possibly be framed with sufficient precision to be binding on future courts. But in any case, that's all irrelevant because the Heller court just pretended that Miller said the opposite of what it said and moved along. So they've overruled it in effect by mischaracterizing it so badly.
Okay, well, on behalf of the Independent Institute, thank you for coming, and please won't you join me in thanking our speakers.